Please state your name again for the record.
Yes, thank you, Mr. Chairman. Ken Conley from Alliance Defending Freedom.
Representative Crane.
Thank you, Mr. Chairman, and Ken, good to have you back with us today. Representative McCrosty and Representative Jordan have raised some very important concerns, and as we talk about this issue, those that are in opposition to House Bill 2 have continued to bring up the issue of lawsuits, and that was kind of the line of questioning that they were heading down this morning. Could you update us, for example, on the Houston case? What happened in Houston and some other cases around the country with respect to florists or others that these lawsuits have been brought forward?
Thank you, Mr. Chairman. Thank you for your question, Representative Crane. The City of Houston issue is instructive, I believe. What happened in the City of Houston was they passed what we would term a bathroom bill or a gender identity bill that was being discussed yesterday that would make all bathrooms gender neutral. That was passed by the City Council and at the behest and the urging of the mayor. As is the law in the City of Houston, the people are permitted then to challenge the passage of that bill by collecting a certain amount of signatures. They collected approximately 3 times the amount of signatures, submitted them through the proper procedures, and they were rejected by the authorities in the City Council. At that point, they had no choice but to file a lawsuit because all the proper procedures had been filed, and it would have gone to a vote of the people, that bathroom bill. At that point, the mayor and the City Council hired a high-powered law firm who then subpoenaed the communications and sermons from 5 area pastors, who were not a party to the lawsuit, by the way, to see what their communications were with regard to the city's passage, the original passage of the bill, and to see if they had said anything critical of the mayor or the City Council with respect to the bill. Now, the fact that that's blatantly unconstitutional and is protected by the First Amendment, all those communications, did not stop that law firm from subpoenaing the pastors. So while it might sound great to say churches have constitutional rights, look them up, you have them, enjoy them, that's cold comfort to a pastor who has been subpoenaed and is now standing before a judge having to get his own law firm to now write a motion to say, I have constitutional rights, Your Honor. It puts the pastor and the church in the dock. And as I said yesterday, the Constitution is the supreme law of the land. You shouldn't have to justify what you say in the pulpit to a court of law. And the same thing goes for businesses. The default position is that they have a First Amendment right not to create expression, not to have to say what somebody else wants them to say, whether that's the government telling them what they want to say, or whether it's another private party telling somebody what they want them to say. So the same principle applies. But I don't think it's an answer to say you have constitutional rights, defend them in court. Once you're in court, in a sense, you might win, and you should win, but it's a little late if you're a businessman or a pastor to be spending your time doing that.
Okay. I don't know if Representative McCrosty and Representative Jordan have any other questions that would relate to this particular topic. But the issue of lawsuits has come up a lot with asking bakers or, cake makers that they would have to, bake a cake or decorate for a wedding. Do you see the passage of House Bill 2 currently? If someone were in the state of Idaho, we don't have House Bill 2, they couldn't sue, but if we pass House Bill 2, do you see that that's going to open them up for lawsuits if they refuse to do those services?
I don't think there's any doubt that it will. Everywhere we've seen sexual orientation and gender identity added to non-discrimination or civil rights statutes like this, we've seen that happen. And again, if you look at, say, not to get too legal on you, but if you look at, say, the New Hampshire license plate case, if you look at the Pledge of Allegiance case, the government can't tell a private individual what to say, what to believe. And this, in the same fashion, a private party can't walk into a business and say, I want you to print this, I want you to say this. It's against the Constitution. But what this bill does, it puts that businessman in the dock, and then he's got to plead the Constitution. The reason you don't want House Bill 2 is because you don't want that to happen.
Okay.
Representative Crane, do you have a follow-up?
Yeah, I got a different line of questioning, Madam Chairman. You used a term that I've not heard before with respect to gender identity. You called it a bathroom bill, I think, in Houston, Texas. Is that what, if we add gender identity to the human rights, would that allow individuals in the state of Idaho, transgender people, to go into a woman's restroom or go into a woman's locker room? Would it afford them those rights?
Mr. Conley.
Yes, thank you, Mr. Chairman. Mr. Chairman. Yes, Representative Crane, it would. Essentially, what it would require is gender neutrality with respect to locker rooms, bathrooms. And as we spoke about a little yesterday, that's obviously going to place businesses in a no-win situation. They can't do both. They can't follow House Bill 2 and have gender neutrality and at the same time protect their patrons from other folks who might want to take advantage of that situation. So it would definitely allow for gender neutrality. It would actually command gender neutrality.
Final question,
Follow-up.
Madam Chairman. Yeah. So I've been hearing all along that places of worship are protected. So in my church, if a transgender individual decides to come and attend church, they can go into the female bathroom, and that church would not be protected for refusing to allow them to go into the bathroom if HB 2 is passed?
Mr. Conley.
Thank you, Madam Chairman. Representative Crane, that's a slightly more complicated question because it would appear to look at the law, whether it's a public accommodation, the religious, but certainly with respect to employment, religions are going to be in the dock because it only protects a co-religionist. So as far as employment goes, your church might have to employ a transgender individual who does not follow the precepts of your church, but they may be the same religion. So your church would essentially be stripped of its right to employ people of faith who actually accept the statement of faith in your church.
Thank you, Madam Chairman.
Thank you, Representative Crane. Do we have any additional questions? Thank you for yielding to those questions.
Thank you, Madam Chairman.
Thank you. Lori Birchfield. Welcome to the committee. Please state your name
Thank
for the
you.
record.
Honorable representatives of the State House Affairs Committee, my name is Lori Birchfield. I've been married 35 years to my husband, Darryl. I'm a mother of 4 and a grandmother of 5 so far. I have a small business. I've been a small business owner for 22 years in the Meridian area, and I'm here to vehemently oppose HB 2 and ask that it not leave committee. I have a deep love and compassion for all people, as Christ has taught me, and by the incredible example of my parents growing up. With that said, that love and compassion does not mean that I condone the LGBT lifestyle. The words sexual orientation and gender identity are undefined and open up a Pandora's box of sexual preferences which minimally include up to as many as 70 and or up to minimally as 50 and more than 70 sexual preferences worldwide that I could find. Members of the committee, do you really want to legalize under this bill pedophilia, sadism, necrophilia, bestiality, exhibitionism, polygamy, and many others? And those are all within this undefined term. And it may be in part of the negotiation section that if you had a grievance, you would have to go through. But beyond that, it is not. It is not in the law that we are looking at. This is a dire concern to me, and I know to thousands of women across Idaho who are not able to be here today because they are home with their families and their children that they are raising. Our laws were designed to protect and to keep safe the citizens of Idaho. Elected officials have a duty to ensure the protection, privacy, and safety of citizens throughout Idaho. As a very active grandmother, I often travel with the kids to their public venues, including vacation destinations such as McCall, Sun Valley, Bogus Basin, and locally my health club, YMCA, zoos, and other children's attractions such as Roaring Springs, Discovery Center of Idaho, local libraries, state and local parks, and campgrounds. As I'm sure you committee members are aware, as parents and grandparents yourselves, these sites all have public restrooms. Until now, I'm sure you wouldn't have thought twice about sending your young boys or girls into their appropriate bathroom sites. Everyone should be free to go to a public restroom without fear of people of confused sexual orientation exposing themselves to our children or flagrantly and unnecessarily parading their genitalia in the locker rooms of our YMCAs and gyms. My youngest grandchildren spend time in the facility's childcare area in which they share the adult restrooms. Please tell me that you're not, or that you are willing to protect the privacy and safety of women, children, and young adults in elementary, junior high, and high school locker rooms and bathrooms. You can be compassionate to your fellow citizens without putting the majority at risk. Who would have ever thought that the mere act of sending your child to a public restroom could result in a negative and positively or possibly dangerous life-changing experience with dramatic and long-lasting repercussions? We do not need SOGI legislation. Idaho lawmakers' duty is to protect and constitutionally uphold the freedoms of all citizens of Idaho. Thank you.
Thank you, Ms. Birchfield. Do we have any questions for Ms. Birchfield? Thank you for your testimony. Want to remind those in the audience that we had really wonderful decorum yesterday, and that was a long day, and we encourage that again today because the chair will not stand for it otherwise. So if we can be respectful of the speakers on both sides, I highly encourage that. Darryl Birchfield. Please state your name for the record.
Darryl Birchfield. Honorable members of the committee, I've been a realtor here in Boise for 16 years. I also have several short-term rentals that I manage. This has given me the opportunity to garner insight into exactly why people, as of late, are seeking to come to Idaho. One of the most striking factors, and by the way, I'm not asking them why, they're telling me why. And one of the most striking factors contributing to their desire to visit and perhaps move here is the perception that Idaho is a very tolerant, low-crime environment in which to live and raise a family. Yet, here we are, entertaining debate about a bill that by its very nature would seek to diminish our ability, as established by the First Amendment to the United States Constitution, to freely exercise our religion, our freedom of religion, and adhere to and obey the tenets of our faith. Contrary to the opinions of a few, and I know there's been several people that have testified that businesses have purported that they would not consider moving here, that the political nature or the diversity or lack thereof for the state of Idaho is one of the reasons they would not come here. But I am here to tell you that by personal experience, me talking to these people over the phone without me instigating the conversation, initiating the question, they're telling me, and it's interesting, those who were here last night, the lady that had moved here from a certain state that starts with a C and ends with an A, that she was told to remove her plates, that the majority of these people that are calling me in regards to these short-term rentals are people that are coming from generally that area, and what attracts them here is the fact that we are seen as having a very tolerant, low-crime place in which to raise a family. And this, I'm going to be blunt, this hits you right in the pocketbook. People are desiring to come here, and I think that this bill that's before you now would work to the detriment of those when they see things like what's happening in multiple places, and how this bill has been, bills and bills like it have been construed to attack people of faith, that diminishes their desire to come here. Fortunately, I'm going to be brief. I would like to encourage you to vote no on this, that it not get out of committee, and that if it were to move forward, it would be a detriment and inhibit the growth, prosperity, and the liberty that we all seek. Thank you for your consideration, and please vote no on HB 2.
Thank you, Mr. Birchfield. Committee members, Representative McCrosty.
Thank you, Madam Chairman. Mr. Birchfield, I've heard you and others say that Idaho is a tolerant state. And we've also heard other individuals testify that there's a concern, a strong concern, of the amount of tolerance that Idahoans have. Is one side of those definitely right, or is there a gray area in between?
Mr. Birchfield.
You might have to define that a little bit.
Representative McCrosty, would you please clarify your question?
The question that I'm trying not to ask is, if one side says that there's tolerance and another side says that there's not tolerance, which side is right?
Mr. Birchfield.
I don't, as I said in my opening statement, that I am not asking these folks what their particular, which way they lean. All I'm asking, all they're telling me is, I have heard that Idaho is a tolerant state. It's a friendly state. It's a low-crime state. And for those reasons, they want to move here. So to answer your question to any further extent than that, I really can't. I can just tell you by firsthand knowledge that these folks that are looking to come up here, they want to come here because of what they know, what they've heard from other people that have been here, that have called back and said, you know what? Idaho is a great place to come to, and evidently, whatever we're doing right now is right. Because I haven't had a single person call up here and say that they've heard anything negative about this state. So I can only testify to what I personally have heard.
Thank you. Thank you, Mr. Birchfield. Did you have a
Thank you.
follow-up or any other questions? Thank you, Mr. Birchfield. Next, we'll have Julie Lindy. Julie, before you start speaking, we have signed in next Barry Peters. Is Barry here today? Right, I'm calling up some new folks that will be in line. Barry Peters, Ferry Hitchcock. Thank you very much. Would you make note of that, Barry Peters? Barry Peters. Did you say Barry or Ferry would be here tonight? Barry, okay. And then we have Ferry Hitchcock, Joel Robinson, Dan Trantham. If Dan Trantham, and is it Time Trantham? DW and TM. If you could please come forward to the seats that are reserved, so we're just trying to get folks lined up. And then Jim Busby. Ms. Lindy, thank you for waiting for folks to come in. Please introduce yourself to the committee for the record.
Good morning, Madam Chairman and members of the committee. Thank you so much for having this hearing. My name is Julie Lindy. I am the Executive Director of Cornerstone Family Council. Cornerstone Family Council is a state-based, born in Idaho organization that strives to make Idaho a place where God is honored, religious freedom flourishes, families thrive, and life is cherished. I've been cutting and pasting my testimony since yesterday so that I don't repeat things. And I want to talk to you on three different things. I want to talk to you about the definition issue, the issue of vendors, and also on public accommodation. The one thing I do want to repeat, though, is I think we can all agree that no matter what side of this issue we are on, every person must be afforded compassion, love, kindness, respect, and dignity. Hateful and harassing behavior or attitudes directed towards any person, regardless of the reason, is to be repudiated. However, House Bill 2 is an affront to our constitutional freedom of association, speech, rights of conscience, and does inhibit the free exercise of religion. We're here to ask you to vote no and hold it in committee because we feel it's bad for Idaho, bad for the marketplace, bad for the church, and the public accommodation component makes it dangerous for women and children. Now, to discuss the definition issue, we often hear it's 4 words, just 4 little words. Just add the 4 words. It's simple as that. But in reality, it's not just 4 words. It's 4 words that in House Bill 2 have not been defined. 4 words that have pages and pages and pages of subcategories and definitions. Organizations cannot even really agree across the spectrum as to what all is included in those 4 words. 4 words whose categories and their definitions are fluid. The American Psychological Association defines gender identity in part as one sense of oneself. In other words, you self-identify in gender identity. Sexual orientation has multiple categories, they say, and they continue to be widely used, but research, they say, has suggested that sexual orientation does not always appear in such definable categories and instead occurs on a continuum. Yesterday, one of the presenters said, when asked the definition of sexual orientation, said, you just know it when you see it. I can't ascribe to that definition, and it looks to me as if the American Psychological Association doesn't either. Facebook, which we know is widespread social media use, has 51 to 58 different gender identities in the United States. In the United Kingdom, they just added 21 more to the definition of gender identity and sexual orientation. So whether it's the courts or the culture, this is a fluid definition. When you get to the other distinguishing, like the immutable characteristics, race, sex, and then religion as is protected in the First Amendment, those have never been arbitrary or fluid. So there's not been the confusion in the courts and the culture as to what these words mean. So no state agency or elected official should use their power to coerce or force a citizen of Idaho under threat of punishment to surrender their constitutionally protected freedoms. Let me discuss a little bit about the vendors, because a lot has been made about wedding vendors, for instance, cake bakers, florists, photographers. And I will just revisit the example of the hitching post in Coeur d'Alene, because that's where their business lies. And Alliance Defending Freedom, who you've heard from, was their lead counsel. Now, the hitching post, it was discovered that the hitching post, after being told they had to comply with the ordinance in Coeur d'Alene, then they were told, you know what, you don't have to. And in your packet that I gave you yesterday, I put an article from the LGBTnation.com, and is it okay if I read from that, Madam Chairman?
You may read.
The reason I want to discuss this is because in this article, the discussion of the hitching post story is told, and the acting executive director of the ACLU at the time made a statement. He said, however, it's saying that they would not sue at this point. He said, however, the ACLU would reconsider its position if the hitching post begins to offer secular services such as providing flowers, cake, or hold non-religious ceremonies. So what that statement did is it raised the threat level for the hitching post. And it put them in the crosshairs, knowing that if they chose with their own family business to grow their brand, to move in a different direction in terms of what services they offer, they now know that if the ACLU does not define it as religious, that there will be a threat of a lawsuit. And lawsuits are expensive. They're expensive from the moment the threat exists. It's not something that just happens, you go to court and you pay your fees and then you go home. Years and years and years of litigation and reputation and time away from a business. To be given our First Amendment rights only if the government agrees with our beliefs is just completely wrong. Now, under the public accommodations component, I find this component objectionable on an extreme level of credulity. The protection, privacy, and safety of women and children is paramount, and this can't be negotiated. Legally inviting men, whether heterosexual or homosexual, into public restrooms, locker rooms, and dressing rooms used by women and girls needlessly compromises protection, privacy, and safety of women and children. I spoke with a woman who overheard me talking about this at church to another friend, and she came up to me and said, her face was white. She came up to me and she said, this bill can't happen in Idaho. And I said, well, the hearing is Monday, and we'll see how it goes. And she said, no, you don't understand. It can't happen. I said, well, what do you mean? She said, when I was 4, I was sexually molested. And then she said, and then at 18, I was raped. She said, I can't relive the trauma. I can't relive the trauma when I just need to go to the bathroom, wondering if there's going to be somebody in there that reminds me of my attacks. This is a big deal for women. This isn't about whether a guy can wear a dress. It's about whether he can take it off in front of your daughter, your wife, your mother, your sister, your aunt, your niece, or the friend I just mentioned. In fact, since gender identity is self-defined, he doesn't even have to try to look female. So in the bathroom, I wouldn't even know that he self-identified as a woman. He just has to say, hi, I'm a woman. House Bill 2 is bad for freedom, bad for Idaho. Idaho is already a kind and tolerant state full of good, caring, and compassionate people who are happy to live and let live. In the end, House Bill 2 is really about creating a special class and giving social engineers a license to bully fellow Idahoans in the marketplace. I urge you to vote no and hold House Bill 2 in committee, and I have a copy of my remarks as well as legal analysis from national organizations if I can submit them as well.
Those will be submitted into the record. Thank you, Ms.
Thank you.
Lindy. Do we have questions? Representative Jordan. Seeing no questions, thank you.
Madam Chairwoman.
Representative Wintrow.
Thank you, Madam Chairwoman and Ms. Lindsay. Is it
Lindy.
Lindy, I'm sorry. Thank you. Ms. Lindy, you mentioned a few things from the ACLU and some of the cases, and great opportunity. I noticed I think there's an ACLU attorney here, and maybe I would ask if we could ask him to address some of those questions and some of the cases that were mentioned.
It's fair. Who is the ACLU attorney?
It's Richard, I think, Madam Chairman.
That sounds great. If you will step forward, we just heard from ADF, so this is rare that we hear from both sides. We do want to remind the committee, we do have stacks to go through, so